This will deal with the matter of KKs for his children.
Yes, madam.
May it please your lordships, in this matter...
Sorry, did I hear you use names?
I'm so sorry. I'm so
Really,
sorry.
at the start of the hearing, that's not a good idea.
No, I do apologise. I should not have done that.
Well, we are where we are. Can we be absolutely clear just to use initials, talk about the father, the stepfather, the mother?
Of course.
And even for the witnesses.
Of course, and I must apologise.
No, well, no, but we must be careful.
So, I represent the stepfather in this matter, who sits behind us with Miss Sandra Fisher for the local authority. We have Mr. Edward Lamb with Miss Vindis, Mr. Edward Lamb, of course, of King's Council. For the mother, we have Mr. John McEwen of King's Council, together with Lauren Bovington of Council. And for the children's guardian, we have Mr. Mark Toomey of King's Council and Victoria Roberts. Finally, for the child A, we have Miss Joanna Yule of Council.
Now, have you agreed between yourselves a timetable for submissions?
There hasn't been specific discussion of that issue. We, I think, communally considered it would be likely that we might be guided by the court as to...
well, the court is often assisted by counsel having got together sensibly, as one would expect, and had a word. But I think, broadly speaking, the appellant group, if I can call them that, should be finished with their submissions in the morning.
Of course.
If it may even not take the morning, we'll have to see. There is a second point, obviously, is there's a good deal of, I don't say this by way of criticism, there's a good deal of repetition between the points made in the skeletons for the appellants group. And if you, as I imagine, are going first, those coming afterwards should think carefully about the extent to which they need to add, or the points on which they need to add. I imagine all that is common sense to you. But you should leave enough time that there will be points they will need to make for their particular clients, and you must leave enough time for them to do so before the end of the morning. That work?
Of course.
Yes.
Yes.
And then in the afternoon we'll see how it'll go. Obviously, Mr. Lamb, and we'll see what the role of the guardian should be.
Of course.
Very well. Can I just make two other general points? We've all read the papers with care, not always very easily, because the bundle references don't marry up to the skeletons, and there are some difficulties in establishing precise chronologies at times, but we've done that. We would encourage you to focus not on generalities, but on the particular points at which you believe that the judge made errors which enable this court to say that her decision was wrong. And that means effectively specifics with chapter and verse and taking us to the relevant passages in her judgment and the documents that show she was wrong or in the way that you allege. So I'd be grateful if it was a specifics focused submissions. Second point, it's the view of all three of us, and I don't think it's opposed, that the mother should have permission to appeal. Grateful? Not opposed. Right.
Thank you, my lord.
Off you go.
I want to just check whether you have had receipt of an amended skeleton that was provided yesterday. I'm afraid late.
Yes,
by
well,
E5.
in fact, I got it yesterday evening, but I see I've got it again this morning.
Thank you.
So that's
You've got
good.
a printed copy, yes. And that was precisely because of the problem that my lord has identified, and I am sorry for it.
Well, I did actually use this one once I got it, and even then some of the references didn't seem to work, but that may be my incompetence. These points are manageable, so let's just get on with it. Yeah.
Thank you. My lord, you have obviously a full grasp of the points we made. What we challenge is the forensic integrity of the very serious findings of sexual abuse that were made by this judge in relation to the stepfather. This, as you know, is a case where there was no ABE interview capturing any allegations. And what we say happened was the judge relied upon evidence that was poorly captured, poorly recorded, in circumstances where none of the relevant guidance that is so important in these cases was adhered to.
But she was aware of all those difficulties and says she took them into account. So you've got to show us where she failed to take them into account, despite saying she did.
Let's begin, if we may then, with the first round of allegations. And those were made by the child A in January of 2022. Now, the allegations were
Well, they weren't the first allegations, were they? The first allegations were made considerably sooner to the mother.
We challenge whether those are correctly categorised as allegations, in fact.
Well,
based purely on the forensic
Well, the mother,
evidence.
in her evidence, accepted that the child had made known to her things that had happened that obviously caused her discomfort.
Yes.
Now, I actually don't have the same degree of sensitivity about whether something is an allegation or a disclosure, but certainly a child of that age saying what the mother said was said to her was making a disclosure of something. So when you say the first round of allegations, they're the first round of allegations when A was sentient, but there has been something before.
Well, let me address that, my lady. It's quite right to point me in that direction. The first information, allegation, disclosure that was made is evidenced only through what the mother and the stepfather have told professionals and then the court. And so if one then thinks about the forensic integrity of that evidence, we are talking about something that had allegedly happened some 5 years before, 4 or 5 years before the first point at which it was ever spoken about in a way that has been captured for the purposes of this trial, this hearing, these purposes, as it were, and is therefore subject to all the fallibility of memory. There is no information available as to what questions were asked of the child.
Those are all perfectly good points as far as they go, but you're not suggesting that something didn't happen between the child and the stepfather that caused the child to be sufficiently troubled to mention it to her mother.
Well, it was mentioned.
The mother herself gave that evidence, and the stepfather accepted that because the mother asked him about it.
Firstly, the child mentioned it because her mother observed the child kissing her brother. That then resulted in the mother asking the child how she knew about that, or how she knew about that activity, as it were. That resulted in the child saying that she had been shown by her stepfather. We don't know, in fact, how the mother approached it in terms of questioning.
Well, you're going too far ahead, because this was something, as you indicate, wasn't only a disclosure or something said by the child, but it was the child's behaviour at the time that caused the mother concern.
It was, but behaviour which in pure terms could have many interpretations.
And the mother would know that. So if you see a little girl kissing her brother affectionately, you're unlikely to say to the little girl, how do you know how to do that? Because children do kiss each other when they're siblings. So I think you've got to be, if I may say so, I think you're falling into the trap that my lord warned you against, that we don't want generalities. We want you to take us to those parts of the judgment that you say demonstrate that the judge had erred in not making a complete forensic analysis of all of the evidence, rather than try and explain the evidence without that reference.
I see.
To the
I
judgment.
will do my very best. The aspect of the judgment that relates to what was or wasn't alleged in the early part of 2017, 2018, I'm just turning to the appropriate reference, and I do apologise for the short gap. I think the points that we make about it are the limits of the evidence, which we say the judge simply did not take into account in placing over-reliance on...
Well, would it be helpful for you to show us first, in the judgment, where the judge refers to this incident, refers to the first disclosure, if we're going to call it that, and effectively to what the mother said about it, and then, if necessary, if you say that's incomplete, show us the document on which it's based.
Of course, my lord. Just give me a moment, if you would.
Of course.
So, my lord, if I can go to the analysis section, please, on page core bundle 104.
Yes, thank you.
At paragraph 195.
That's my bundle, that's on page 105. Yes, here we are, thank you.
We can see the judge making reference towards the bottom of the paragraph to the mother's acceptance that A had informed her, told her in 2017 the stepfather had kissed her, and the rest you can read. Now, what we suggest is lacking is any further forensic analysis of...
And where, sorry, where in the what's the page reference, or what's the documentary reference for the mother's acceptance that she'd been told in 2017? Or is that purely something that came out in her oral evidence?
No, my lord, it came out in the interview of the mother that was conducted in 2020.
Right, I was asking for the page reference to that.
Yes, and I will just...
Can I just say, it wasn't, we've got, it's always helpful to have a chronology, but the chronologies that we have got, we've got two. Don't have these sorts of page references in them. If they have, they appear to be, yes, they're both the bundles that were before the family court. It would be very helpful to have them updated so that we could follow the cross-references into the documents that we've got.
I note that.
With all these counsel here, somebody might have thought to do that. Anyway, I've got that off my chest. You were going to show us.
Yes, my lord. It's in the core bundle at page 155, line 28 onwards.
Is it also something that we should do to go to the judgment again, and that part of the judgment where the judge details the evidence that she has borne in mind? And if you look at paragraph 144, we see that she says the mother's evidence was that
Yes, yes, and
the stepfather first told her about A's inappropriate behaviour towards her siblings in 2017. During cross-examination, the mother said that the stepfather told her that he'd seen A kissing B and C, and that he'd seen A with her hands in B's pants.
that's right. The evidence that originated from the transcript of interview of the mother was obviously further forensically expanded and tested in oral evidence. There was some degree of disparity between the mother's account and the stepfather's account of what they each remembered having happened in 2017 or 18. But you're right, my lady. The starting point is this transcript of interview at 155. There was, of course, further exploration of the issue.
Sorry, 155, what are you referring to?
Line 28 onwards.
Page 155. I'm so
Yes,
sorry.
page 155. Thank you, Mary.
Let me just have a look. I'm worried the page references aren't right. Line 28 onward starts okay.
Yes.
Oh, good. That reference is right then. Thank you. Thank you.
And so, my lord, if we read on, the transcript diverts to some degree, but you'll see all the way through to line 30, I think, is really where this draws to a close.
So really the whole of the following page.
Yes.
Right, again, I'm sorry, I think we need to start at page 154 at line 22.
My lady certainly sets into context the interaction that took place.
Well, the mother says, and then I found her myself.
Yes.
Yeah.
Yes. That's which triggered the conversation with her child.
Yes, well, thank you. That's very helpful. So that's, as it were, the material.
That's the material, my lord.
And what do you say the judge did wrong in her approach to that material?
What we say, my lord, is that the judge did not interrogate the fundamental weaknesses in the way the evidence was inevitably captured in this regard. It wasn't captured at the time.
Well, hang on, but the evidence was captured in front of her in the.
Yes, sorry, what I mean is...
Isn't the key evidence the evidence that was actually she heard orally?
Of course, but of course we're then referring to events that were many years previously.
Well, that, of course, I accept, but I mean, that's just a fact.
And we're also referring to a discussion with a child who was very young at the time by a mother who had obviously had no knowledge of the way in which a child should be approached to discuss matters of this kind, who may have overinterpreted what she saw, it is possible that that's the case. And I make that point because there is no history anywhere else, no observation of A displaying any kind of behaviour that might be interpreted as sexualised at any point in her life. And the judge in our submission simply does not tackle any of the forensic challenges that emanate from all of that.
Well, what forensic challenge is there? She's got evidence from the mother that the mother was told something by the stepfather, that she then witnessed herself behaviour that she regarded to be sexualised. What's the forensic exercise that the judge has got to perform in relation to that, beyond, do I believe the mother who's giving evidence against interest? Or, I mean, you don't suppose, do you, that judges take into account the fact that a parent may not know how to deal with a child in terms of ABE interview techniques? That's unrealistic, Miss Howe. So what should the judge have done? Yes, there was a young child and a mother who was obviously absolutely horrified by what she saw. So what did the judge do wrong with that information?
All of what my lady has said thus far is self-evident, but the point that we try to establish is that the series of events is clear. The interpretation of what the child said as being acts of sexual abuse is far from clear. There is scope that mother overreacted to what she saw, that actually the explanations that were being given by the child, who herself did not sustain the allegation going forward, were nothing more than the innocent explanations that were given and accepted at the time. The judge simply did not reflect on those possibilities.
Well, how do you know she didn't reflect on them?
I see nowhere in the judgment where the judge asks herself, was this an allegation of sexual harm, or was it actually something which had no or limited forensic value? What were the possibilities that underlay what happened in those events that the mother herself, as you've pointed out, my lady, tells the police about in her interview? I understand, of course, that the judge has to look at the big canvas and has to take all of the evidence into account. But we say the true forensic value, and I know I've used these words before, they may not quite capture the right essence of what I'm trying to drive at. But we say that the judge wrongly elevated these into clear allegations of sexual abuse, where without any exposition of what we say were the forensic weaknesses associated with it.
Well, you keep saying forensic weaknesses, but I'm not sure what you mean.
Ah.
There may be other explanations, but this mother, when her child was considerably younger, saw behaviour and had reported to her behaviour that caused her concern.
Yes.
It was out with the child's perception of matters sexual, or should have been at that age. And she tells the child, according to A, I've spoken to your stepfather, you will be safe. So I'm not quite sure what you think the judge should have done with that.
I suggest that the the interrogation which I keep referring to comes back to the authorities about relying on the evidence of the child to make findings. One has to have regard in our submission to the quality of that evidence, the way in which it's been captured and recorded. So the events themselves, I understand, my lady, are provided by the mother. She tells the court about what she recalls happening in those years. She expands upon it in oral evidence. But when we get down to the granular evidence of what the child has said, which the judge relies upon, our submission is that that's where the deficiency lies. There is no substantive analysis of the potential that these were not, in fact, allegations of sexual harm.
But can you explain what you mean by that? I don't know what you mean by that. So if a child comes and says, my stepfather asked me to lick his dick, I'm sorry to be so crude, but how can you see anything other than that as a sexual abuse allegation?
That was not part of the picture in 2017-18. The only aspect...
No, but you're moving backwards and forwards through the years, saying that the judge failed to grapple with the granular, which is that the recordings of what the child said were inadequate. And we have the mother's evidence.
I think I understood it, your submissions were, at the moment, just limited to this episode.
Yes.
And a point that will be made is the extent to which it's necessary for the judge to carry out an exercise episode by episode, because there are 4 or 5 different episodes of allegations here. And
we say, my lord,
to some extent, she's got to take the whole picture. But your criticism is, as I understand it, that in relation to this episode, which we've taken you to because it's the very first, you can't find in the judgment, and we'll tell you later if you can, an analysis of this particular episode saying, well, this was weak because it's second-hand anyway, and the mother may have interpreted the situation and it was all a long time ago, and so on and so on. That's essentially your point.
Yes, it is, my lord.
Yes. Well, thank you. That's the 2017 episode.
Yes.
I mean, you must go where you want to now, but I think both my lady and I find it helpful to start at the beginning.
Thank you. And indeed, just to say, just to round that off, the timeline of that episode remains unclear as well. We're not entirely...
Timeline in what sense?
As to when it happened.
Well, does that matter? I mean,
Probably not.
We know roughly.
Probably not. We know the period of time, although, of course, the child in 2017 was 7.
Can you speak up a little?
The child was very young at the time.
Yes, well, that's all evident. Yeah.
So, my lord, we then, I think, then move without any further evidential evidence of any difficulties in the family to January of 2022. Now, in this regard, we would suggest that there were enormous difficulties in the collection, capturing, recording of the evidence that was material. This is something that the judge does turn her mind to, and I can take my lordships to page 107 of the bundle. And paragraphs 207 and 208. of course, accept that the judge, on the face of it, records that she has taken into account that some of the primary evidence is lacking and that the record keeping was poor. And she gives a narrative account of some of the reasons why that is. So moving into paragraph 208, she comes to a point where she records that I'm satisfied that the questions asked by DL and BCL at A's school were more likely than not appropriate and followed guidance. And that seems to be what turns the case into one of proof.
Sorry, we're in 207, are we?
We're now on paragraph 208, which is page 108 of the judgment.
Yes, I'm satisfied the questions asked were more likely than not appropriate and followed the ABE guidance. That's you say that's the crucial sentence, are you?
I think that's a crucial sentence, certainly in the judgment, and I'm not, of course, discounting what else the judge says about it. And at paragraph 209, she continues in her analysis of the evidence. And so then turning to the challenge that we make in relation to these findings, if I may, my Lord, take you in the core bundle, firstly to page 619.
Helpful just to be told which volume these are.
Of course, I'm sorry, in core
it's in two, isn't it? So I did put stickers on the back of the bundles to tell me which pages were in which, but they've fallen off. 619, yeah. So this is the MASH referral from January the 18th.
That's right. And it was accompanied by a statement of evidence from Miss Lawrence, who, when she made that statement, had not had sight of her records, who had left the school, and who said she had no active recollection of events. So she was dependent on her record. The MASH referral, well, of course, the way in which this came to Miss Lawrence's attention was through
DL, according to her.
DL. So sorry,
No, don't worry.
Second offence. The way in which DL came to find out about these events was, as we know, through another student coming to her, because A had told her friend or friends about events at home. We don't know what that was. We don't know what A said to her friends.
But does that matter? I mean, the judge doesn't attach any importance to that. It's crucial, is what she told DL, isn't it?
It is, but of course the evidence capturing exercise is it's a chain. And what A has said to one person may actually, it may be important to understand what's being said at the very beginning of that chain, to understand how the chain evolves and where the influences might lie that render what has been said unclear or unsafe. That's perhaps the wrong word to use. But we're missing a piece of the jigsaw in our submission. It may be regarded as a small piece, but it is part of it. And when we come to looking at the November allegations, we'll see the same point arising.
Sorry, the missing piece of the jigsaw is the friend
Yes, what A said to her friend or friends, what was discussed, what was alleged.
Well, I suppose there are 2 points there. One might be if she'd said something inconsistent, and that would mean that that's a piece of evidence that might have helped the stepfather. That's a purely forensic point. But a more substantive point is that the tale might have grown in the telling. The friend might have said, "Oh, did he do this?"
Yes.
And oh, maybe he did. That's the sort of thing. We just don't know whether the friend has contributed to the substance of the story.
That's
Yeah,
exactly
I
it.
agree. We don't know that. Yeah.
That's exactly it. We then have DL's MASH referral, and this was the subject of oral evidence because, of course, there were questions as to how this account had been captured. And as is, in fact, reflected in the judgment, DL was unable to provide any contemporaneous note. She could not recall the questions she had asked. She fell back, as did the judge, on the fact that she has training and therefore is confident in her ability to ask open questions. But we don't obviously have any record of the questions that were asked or the detail of the exact answers that were given. This note
This point was
after
made to the judge, and the judge considers it head on, forms a view about DL, which she had heard and we haven't, that if DL says she would have asked open questions, appropriate questions, the judge could rely on that. Can we go behind that?
Well, we say you can. When you look across the piece at the value of the, I keep using that word, I'll try and think of an alternative. When you look across the piece at the proof of these allegations, time after time, we see departures from the sort of practice that we are told is so vital in cases of this kind of abuse, where the court is dealing, particularly in a case where the court is dealing with what a child has said in the absence of any ABE interview. We haven't yet even touched on the counterbalance to this, which is what A has actually been saying for a very long time and has said in ABE interview, which was appropriately captured. So we're focusing just on what the building blocks were for the judge's findings of abuse. And we say the weaknesses have started before DL is even in the pictures, as we've already discussed. And here we have what is taken by the judge to be really critical evidence, but without any account being taken of the deficits in collection. We say simply being confident that somebody has asked open questions is insufficient to dispel the difficulty of the questions and answers not being captured or recorded, there being no contemporaneous record of the exchange. There is no information about demeanour, there is no information about how long this episode of question and answer took. There is very little beyond a note that was made after the event for the purpose of the MASH referral.
Very shortly after the event.
I don't dispute that it was shortly after the event. We don't know exactly how long,
No.
but it was made. It wasn't contemporaneous in the true
No,
sense.
I understand.
And we say, whilst the judge therefore acknowledges one point of difficulty and resolves it for herself in the sense that she is confident in DL's questioning technique, none of the other difficulties are weighed into the balance by the judge or even confronted, we suggest.
Did
We
you
then-
make a submission about the missing pieces of the jigsaw?
Yes, I mean, I'm sure we did. Our submissions are in the bundle, and so
And the judge doesn't deal with that in the judgment.
I don't think she does. I mean, that's my submission on this. That whilst there is in the judgment some acknowledgement in places of evidential weaknesses, focus of this appeal is the lack of balance, as it were. We can't see where those deficits have been fully identified and grappled with
Well,
in
Ms.
arriving at
Fisher
the judge's
can
conclusions
perhaps have a look at your,
I'd be
at
grateful.
your submissions
for her.
below to see whether, what I understand the missing piece of the jigsaw point to be, and you may have another point in mind, is that by the time that an account is given to DL, it's clear that the complaint has already, an account has already been given to another child,
Yes.
maybe more than that, and that you made the point that this isn't that the story may already become contaminated before it ever reaches DL.
Yes.
Well, I think it'd be useful to see if that point was made. And
Absolutely, and thank
no
you
doubt
for this issue.
those appearing for the local authority will show us if the judge expressly dealt with it. Yeah.
So, my lord, that is the referral that Miss L, DL, made, and then we move in the next part of the sequence is the account given by A to DCL, and for this we are at core bundle, page 258, moving into 259.
So that's in the other bundle. This is the police officer.
Yes. And in fact, my lord, the
Yep.
account goes forward, and maybe I should say the account goes forward to page 260.
Sorry, I'm getting old. You need to speak up.
I'm so sorry. The account goes through to page 260.
Yes. Yes.
Now, our criticism of the way in which this evidence was treated is that whilst, again, there is reference to the overall difficulties in evidence collection, the judge we submit fails to identify and grapple with the departures that are so obvious from the guidance that exists precisely because these investigations are so difficult.
Would you show us the passage? She does refer to them, doesn't she? Or am I misremembering?
She does refer to...
Can we just see what she says there?
So we're back to paragraph 208 in, core bundle 108.
Yes.
Again, there is a reference in the middle of paragraph 208 that the judge was satisfied that the questions asked by the police officer at A's school were more likely than not appropriate and followed the ABE guidance. So again, there's a focus on the questioning technique, but there is no apparent reference or consideration, reference to or consideration of the real and, we submit, important deficits in the way
Namely?
this evidence was produced.
What deficits are you referring to?
Well, we know that there was prior discussion with Ms. Lawrence, who was in the room when DC Ludwig.
Why is that a bad thing?
It's our submission that the more appropriate approach would have been for the individual to whom the initial account had been given to not be present, whilst a further account was being elicited, a crucial pre-ABE interview account.
Just spell out why.
I've got across the line all. I'm very sorry. I don't think that's part of the ABE guidance, is it?
No, I'm not suggesting that it is, because we will all be familiar with social workers attending for ABE alongside a child that they are tasked with looking after. They wouldn't usually be in the same room necessarily, but there we are.
Well, a lot of social workers actually go into the interview room and are there on the camera.
I do understand.
So, I'm terribly sorry for cutting across my board. So why was it so bad for the police officer to talk to DL first?
It wasn't. I mean, obviously there was a need to have a platform of information on which to base what was to follow. So I'm sorry that I have probably poorly articulated the point.
What's the point you were trying to make?
The point is whether it may have had a bearing on A, that on the same day that she had made allegations to our staff member, she was then invited to speak again about the same material in front of the same staff member. And that, we submit, may have a bearing on what the child then says.
In that case, the practice which you and my lady with much greater experience than me say is quite standard, that the social worker to whom an allegation has been made first, or maybe not first, but earlier than the ABE interview, is present at the interview. Wouldn't that always be the case?
Well, I think I've probably landed on a bad point, so
Okay, well,
I'll move on if I may.
Yeah, that's realistic of you. But we do want to know, obviously, it's crucial. This is a crucial interview. We do want to know what your criticisms are of how, well, I suppose of the interview, but since the judge acknowledged that it was not ideal, we want to know what are the failings that you say she didn't take into account.
So this is not the interview of which the judge speaks when she makes criticisms of departure of ABE guidelines. She's talking then about the retraction ABE.
Yes, I see.
In this instance, what she's talking, when she says she's satisfied that the questions were appropriate, she's talking about what happened at the school in the presence of two social work or social work assistants and DCL and DL. We say the judge does not attach any weight or deal with the fact that DCL had no active recollection of speaking with A. His notes were brief and sparse. There is no record of questions asked or answered. We have some we have a summary, and in fact that's the word that DCL used in his own evidence, that his note was a summary only.
And where do we? That's evidently the case. But why do you say the judge didn't take that into account?
She focused, we suggest, purely on the technique of questioning.
Yes, I see.
And that, of course, is just one part of it.
So if the judge had focused on the technique of the questions and made a finding of fact, which she did, that she was satisfied that it was more likely than not that despite his breach of ABE principles in the actual recorded interview, on the day before, he was likely to have opened up the discussion without leading A. What was wrong with that? What deficiencies should she have taken into account? Because you say she focused on the technique of the questions, and I'm not sure whether you're saying that there's no issue that what's recorded in 259 is accurate. Are you saying it's the technique of the questions that led to the answers being given? Or I'm not quite clear what you're actually complaining about.
What I understood you to say, and you was tell me if I've got this wrong, that even if the judge made an acceptable finding on the technique of the questioning, she should also have taken into account that the notes were very sparse, were only a summary, and they contained no record of the questions asked.
Yes.
So are those the three criticisms which you would make, even if the technique of questioning was all right? It really comes down to not having a full record of what happened in the interview.
Yes, plus what we point to at paragraph 15 of our skeleton argument is also that there was discrepancy between what child A had said or had been reported to have said and the note that was so the point we make at this on page 3 of the skeleton is that there was a part of this account which had been obtained by DL about A putting a chair against her bedroom door, and the rationale for that changed between the point at which DL was speaking to A and when DCL spoke to A. So there was an inconsistency in the account provided by A. Which the judge does not deal with.
Just to spell it out, what the police officer wrote down, so I've gone, here we are, was that he asked her about the chair, and that you make the point somewhere that that suggests that was something he knew about already.
Yes, he did. He did know about it already.
And she did this to stop her younger siblings coming to the room. And what's the discrepancy? Sorry, you said it's in the skeleton, but there's a lot there. What discrepancy, what is that discrepant with?
So, if we go back, please, to page 621 of the core bundle, it's the MASH referral to which we've already...
I see. Right. What you're saying is it's discrepant with what is recorded as having said to DL earlier the same day.
And indeed to her friend.
Well,
the notes here are written. So page 621, my lord.
Yes, we've got it. Yes, thank you.
DL.
So that's the point about him trying to get into. It's not. Well, there's a limit beyond which one can't interpret these. There isn't enough there. In the third paragraph on 621, she simply says that she puts a chair against the door to keep it closed. She doesn't say why. That's only since September 2021. And then there's a separate, slightly different point that she had told her friends. It's not clear whether that's she saying she told her friends or DL reporting what the friend had said earlier. That stepdad was forcing her door at the weekend. She told me it was because he wanted the laptop. So that's the discrepancy that you're referring to, is that right?
Yes, and it also illustrates, I think, part of the difficulty that we've previously alluded to, which is knowing where the information has come from, not being able to really bottom out the evolution of the allegations, which I think is also seen in this chain, as it were. The social workers who were present at this interview made their own record of what A had said. Unfortunately, the maker of that record could not be produced for cross-examination, but we say there were material differences in her note against what DCL had recorded.
That's the one you set out at paragraph 16.
It is indeed. It's in the supplemental bundle that we have extracted here the relevant part of it. And the discrepancies are about location, there's
sorry, yeah, I'm sure you're right. I'm sure it's been put in correctly, but is there page 141, which you give the reference, there doesn't on the bundle doesn't appear to have this passage at all. Can you tell us where it really is?
Supplemental bundle, I think.
Oh, supplemental
Yes.
bundle. I'm so sorry. That's a mistake I've made. No.
Ah, that is unhelpful. I'm sure. No.
I'm sure it's there somewhere. It's just, I'd just like to know.
Of course. Let me just.
Miss Fisher can find it for you, I'm sure.
Thank you. I'm sure she will. Let me go back to the core bundle and see if I myself can locate it. I think, my lord, if we then go, please, to the core bundle, page 117. Here we've got the Singh note of the visit that was made to school on this date.
Well, this is clearly relevant, but is it the same note as we've got at paragraph 16?
Yes.
Let's just, the line beginning A was present with her head of year 7. Am I being stupid? Where is it? Which page did you say?
Yes, it's just under the actual name.
On which page?
117.
Oh, sorry, I was
Name
looking at
Z.
116.
Yeah.
I'm there now. Yes, thank you. Thank you very much.
And again, my lords, in this note, there is no recording of questions asked or answered. It's a summary again, but a summary that contains discrepancies in terms of the location of events, in terms of who was where. And yet this issue is not, these discrepancies are not taken into account, we say, by the
Does the judge refer to the discrepancies?
Not that I don't think so.
Well,
Again,
it's
Ms.
part
Fisher
of
will
your case
correct.
that she didn't.
It's part of my case that she didn't.
Right.
Well, she does earlier on, doesn't she? In the judgment. Because she goes through all of the different witnesses that she heard from. And doesn't she make reference to NON?
My lady, if we go to paragraph 42, on core bundle 65, it's part of the transcript of the judgment.
Did you say, Mr.
Yes.
Thank you.
There is reference to NON, but no reference to the discrepancies in recording.
Well, the police officer, DCL, was challenged on the basis that his note and NON's note did not accord. And he said he stuck by his note.
He did, my lady, but in circumstances where he had no recollection at all of speaking with A. It's hardly a surprise that he sticks by his note, but it's not from an informed basis.
No, but we've got to distinguish between 2 points. One is whether the judge addressed these discrepancies. I'll put it the other way around. One is whether there is a problem about the discrepancies. I see what you say those are. And another is whether the judge addressed those problems, took them into account. Because we're all familiar with there being discrepancies. The judge has got to, as long as the judge is aware of them and takes them into account, they may form the view that one or other witness is reliable or substantially reliable despite the discrepancies. Isn't that really what the judge did in this case?
Well, she didn't allude to the discrepancies.
Didn't allude. Well, 42, we may not use the word discrepancy, but that's the whole point of 42, isn't it? Where she quotes, paragraph 42, where she's dealing with GL's evidence, where she quotes NON's note, and says that discrepancies were put to DL, and what DL said about them.
My lord, those are not the same discrepancies. They are discrepancies about what was or wasn't said to the mother at the relevant time.
Yes, I see. So what is, just from my note, remind me, what is the discrepancy in the ON note that was not put?
So if we go to what...
Well, just give us a headline.
Okay. So whether events took place in A's bedroom,
Or downstairs, is that it? The event.
yeah. Yes, whether she was downstairs in the living room, whether she was in stepfather's room. The fact that NON recorded that A said she had a big bed in her room, whereas which factually was capable of challenge.
Well, just tell us what the discrepancy is at one point at a time.
Okay,
You said there's a discrepancy about the size of the bed. NON said there was a big bed. What's discrepant in DL's evidence or the police officer's evidence?
so the police officer made no record of that being said.
Oh, well, hang on.
I understand that's not a
Discrepant.
discrepancy.
The points made in one and not the other. I suppose you could call that a discrepancy, but that's hardly surprising unless you've got an absolutely verbatim note. Not everybody picks out the same points. But a discrepancy is where actually two contradictory things are said.
Yes, and in that case, the key discrepancy is where the main event happened. Was it down in the living room? Was it in the bedroom?
Yeah. Okay.
But my lord, the reason the other...
Sorry, can I just... Who says it was in the living room? In the records you've shown us? 'Cause I may have missed it, but everywhere I see references to either the bedroom or to A's bedroom. I'm looking at 117, for example. That uses the bedroom or A's bedroom. I may have missed it. I just want to know where the discrepancy lies.
I'm looking at our skeleton argument, page 3 at the bottom. We record DCL as having recorded. I asked her if anything else had happened. She said that when she was aged between 7 and 8 years old, she was downstairs in the living room. Her mum and siblings were upstairs. She said that her stepfather showed her material on his phone. You see?
Is that page 212? Is that what we should be looking at?
I've got core bundle 258.
I thought it was 258. No, I thought it was the police officer's evidence.
And then on NON's note...
Well, sorry, forgive me for... I'm probably being slow, so you'll have to bear with me. I'm looking at 259. And that does seem to refer to a bedroom.
This is DC...
DCL refers to two incidents, one in
Yes.
the bedroom and one in the living room.
Yeah.
Yeah. And
So that's the discrepancy, isn't it? That nobody else had mentioned the living room. Is that the point?
Well, NON refers to everything happening in the bedroom. So
Well,
that's
exactly,
the discrepancy.
exactly. That's my point. So is that the discrepancy?
Yes.
That the police officer had recorded two incidents, one of which was said to have taken place in the living room,
Yes.
whereas NON has said nothing about the living room. Is that right?
Yes, in fact, specifically records a different location. Records a different location, which...
Yes. Well, I mean, again, forgive me being explicit. We're really talking about the showed her his dick and asked her to lick it, and DC Ludwig says that in happened, apparently says that, sorry, DCL said that happened downstairs in the living room. You go 2 sentences back, it all appears to be the same incident. Whereas NON on page 117, well, it's not entirely clear, but the second para says, whilst Mum was upstairs with her little sister, A went into the stepfather's room where he told her to pick his
Yes.
so it's not, that doesn't sound like the living room.
No, it doesn't. And that is the key discrepancy. The other issue that I touched upon about the differences in recording do matter, we submit, because and it may not be that there is a inconsistency, but in NON's material, A makes reference to a big bed, not in DCL's material. The reason that the big bed might have some forensic significance is that we know that A did not have a big bed, and I don't think there was any issue about that. She had a bunk bed, a top bunk bed. So, from the point of view of the person facing these allegations, these differences are material. And yet the judge does not, in our submission, make reference to them. There's no indication that she has considered those issues.
Right. So we're really going through, quite rightly, the core allegations and the core allegations and when they were made. How many more have we got? We're almost there, aren't they? On the allegations, the attractions are different.
We've got the January under control.
Yes, okay.
The November is still to be dealt with, which I'll be happy to do. And I think it would help me to know, would you like me to deal chronologically now with the retraction before I move to November, or would you like the other me to address
I
it?
don't have a strong view about it. My Lord, my lady may have a different view. If it's easy for you, I wouldn't mind looking at all the allegations first.
Of course.
Because that's the material.
Yes.
If that's unreliable, the retractions are simply not being flippant, icing on the cake. But so I think it's useful to look at all the allegations first.
Very well. Of course, I will do so, and we'll address perhaps later
Of course,
the
yes.
value of the retraction evidence, if that's
Yes, so
acceptable. So in November, we arrive at the next round of evidence that's material. And the lead-in to this is at page CB Core Bundle 608. It's part of the school recordings.
this is in the third bundle, yeah? No, the second
Core
bundle.
bundle, yeah.
Yeah,
I'm
no,
sorry, I hadn't remembered. Of course, you'll have it split across 2 files.
3.
3 files.
Don't worry. (608), yep.
This is the record made by
This is the what file, sorry?
staff member CL made this record. It's part
Yes, I
of
see.
the
Yep,
school
thank you.
safeguarding record. Recorded on the 11th of November 22 as having occurred on the 10th of November.
Yep.
CL has been approached by one of A's friends and tells her that A has been confiding in her.
Yep.
That
We can see what it says, yes.
Exactly, and it's in the present tense, so it very much appears to be an allegation of ongoing behaviour. There is again no full note of what the friend told CL. Questions and answers have not been written down. The key sort of core information other than this summary note is not available to us.
Is that a breach of some guidance which has been issued about how school safeguarding records should be?
Yes, there is guidance in the case law about how important it is for school professionals, for all professionals talking to children about issues such as these, to fully record all of that interaction contemporaneously if possible. And of course I accept that circumstances are not always perfect. Training differs from individual to individual. But the guidance is there for a reason, because of the risk of contamination and the need for there to be a clear enough chain in the evolution of the evidence. So yes.
So your first submission on this point is the record we see at page 608 is in breach of relevant guidance.
Yes.
Secondly, do you also submit that the judge failed to take account of that in her judgment?
Yes.
Can we see how the judge dealt with it?
The judge spent some time in her judgment considering the role of CL. I'm just turning, if I may, to the right part of it. Forgive me. So, there is analysis of CL starting at paragraph 52, page core bundle 68. And page 69, paragraph 57, the judge makes reference there to this allegation, and in particular she does note that this is a present tense allegation, and she records, importantly we say, the evidence that what was reported was A speaking about events on the phone to her friend and then dropping the phone in the middle of a conversation. So that
Which paragraph are we on?
So we're looking at paragraph 57.
Where did that evidence come from about A's peer?
CL.
And where in her report is it?
It's not in her report.
That's the point you're making.
Partly the point I'm making.
Well, it's an important point
it is
on the
an
basis
important
that if this is an indication of ongoing
Yes.
sexual abuse, then you would have expected, and it goes back to my Lord Justice Singh's point, you would have expected that to be in the record.
Yes.
Yeah.
Well, CL does record in her safeguarding note that it appears to be an allegation of ongoing behaviour.
Are you looking at 608 now?
Let me go back to it, my lady, if I may. You just
Because I can't see on there anything about the phone calls stopping
forgive me, I'm at cross
midway.
purposes with you, my lady. CL records the fact that it is an allegation of touching ongoing, she does not record.
No, that's
in
why I
this
was
note.
asking where that
Exactly.
came from. So CL's evidence before the judge
Yes,
supplemented
yes,
this report.
yes.
Could we have the reference?
So the reference in the judgment is...
No, the reference in the transcript. We did have the transcript of that passage.
don't.
It's actually okay.
We don't. But I'm sure those who were at trial will reinforce that the oral evidence from CL spoke of this peer of A's being worried because A would drop the phone in the middle of a conversation and not resume.
Do we have CL's statement in the
We
bundle?
do. In
And
fact,
is it
there
in
are-
that statement?
No.
So it must have caused quite a lot of consternation that CL, who hasn't recorded it in the report and hadn't put it in her statement, suddenly says A's peer was left worrying about A when A cut off phone calls at night saying that the stepfather was at her bedroom door.
Yes.
So, I mean, presumably you pointed out to the judge that this was a
Yes.
completely new piece of information.
Yes. Well, whether we pointed out that it was completely new, we certainly pointed out that it was important.
Well, was it completely new?
It isn't recorded in CL's statement nor in the safeguarding.
Where else did it come from?
I'm trying to search back to my memory of
Well,
the
Miss
events,
Howe.
but it must be oral evidence.
Neither my lords nor I were there,
I know,
so
I understand that,
you've
of
got the
course.
advantage of us. So this is quite a significant point.
It is.
But does it appear in your skeleton that you point out that for the first time, CL in evidence mentioned something that was highly critical to an indication that this was ongoing?
We have pointed out the inconsistency. I'm confident about that. I'm just reviewing the skeleton to establish where. Core bundle 752, please, and I'm very grateful to Cindris.
Thank you.
Sorry, can I have the reference again?
752 in the core bundle.
Which core bundle is that in?
It's number 3.
3.
So my lady, from paragraph 36.
So, and these were your written submissions to the court?
Yes.
So paragraph 38, as CL's evidence developed, she told the court that A's peer described being on the phone to A and hearing A cut the conversation short on the basis that KK was trying to get into her room. This is mirrored in the information apparently given by CL to Dr. Powis. I think we can name the professionals.
Thank you, Ruby. So,
But you then go on to say this assertion makes no sense in the context of there having been a lock on the door. Wasn't it more important that this important information does not appear in the report, doesn't appear in the statement of CL, and is given during the development of her oral evidence without notice to anybody?
yes, it's a very pertinent point, of course. And my lady, if my focus has been distracted, then that's on me, as it were.
Well, I mean, speaking for myself, I think those are the kind of issues, rather than trying to tease out what you say are inconsistencies in the records. This is an indication of the records being incomplete and only being expanded upon at a very late stage in the day. I mean, I should think that was more important, wasn't it?
Well, it was certainly important.
And did the judge, in her judgment, deal with the fact that this was given as evidence without any prior indication, save in a report to Dr. Powis?
No, I don't. In our submission, the judge did not allude to any of the new and inconsistent evidence that she heard from this witness, nor did she, as my lady has pointed out, neither did she point to the fact that there was new evidence developing as the trial progressed, nor did she think about overtly the fact that this was an account of A making allegations that were wholly inconsistent with what she has said elsewhere about the timeline of events, plus the picture of a child A who, on her own allegations, which are historic, was acting in a way to cause her peer to panic because she would drop the phone and not resume the phone call. So the peer would be left not having a clue what was happening, but worrying for A, because the whole nub of the dropping of the phone was about the fact that her stepfather was at the door, which, by the way, we now know was capable of being locked in any event.
I do think that you spoil some good points.
Oh, I'm sorry, my lady.
By distracting yourself, by saying, but the door was locked in any event. The issue here that you're taking us to, Ms. Howe-Shawley, is that the judge failed to reflect in her assessment of the witnesses that there were issues with the reporting that she doesn't quite grasp
Yes.
or grapple with, and that it is entirely unfortunate that if A's peer was giving this information, that was a very clear indication of ongoing fear of the stepfather, which should have been brought immediately to the police attention and which should have resulted in the police doing an ABE interview. Because it's not an historical sexual allegation anymore, it's a recent, up-to-date happening event. But rather than the door was locked in any event, I mean, that's what you should be taking us to, surely.
Well, that, I think rather, from the perspective of the appellant, this was an inconsistent report from everything else. From the perspective of the appellant,
Well, it was an incomplete
it's no more
report.
true than the rest.
Yes, but it is an incomplete report, that's your point, isn't it?
Of course it was.
And so if it's incomplete, and then these snippets of information are coming subsequently, then you would say this bears out, first of all, our submission that the judge got her assessment of the professionalism CL wrong. It goes to show that other record keeping may be just as errant. I mean,
Yeah.
I think the inconsistencies point, speaking for myself, are quite small.
So, well, I apprehend my lady's point, and I certainly don't want to talk it down because we agree this was completely unlike anything that A had said before, and yet we don't, in fact, know the detail of what she said. We don't know where or how many times she said it. We have a one-liner, but we'll see as we move through that A never said it again. This is a standalone assertion of current ongoing abuse that has no other reference attached to it, and is allied with this evidence which we, I think, say is important, and I know my lady might think that it's a distraction, but the picture of A dropping the phone,
Well,
reporting ongoing
she doesn't
abuse.
say dropping the phone. She says stopping the conversation. I don't know where you get dropping the phone from.
Dropping the call might be a more apt way. Cutting off the conversation,
Yes.
putting the phone down.
Yes,
Mid-flow.
yes.
Yes. And then not phoning back or messaging or making further contact.
And you say there's nothing in the judge's assessment, looking back, as it were, standing back, as she said, and looking at the whole of the evidence. And this is an important factor.
It is. And it is absent from the judgments, the analysis, or even mention of it.
Can I ask you about something else, which is something I find very curious about the document at page 608?
Of course, my lord, please do.
In the bottom box, which is headed Risk Assessment, recorded 11 November, the second line states, unconvincing and retracted disclosures are incredibly common in sexual abuse cases. Now that, because as I understand it, the witness CL, please correct me if I'm mistaken, as I understand it, the witness CL didn't then report this to the police, for example.
Referral was made, my lord.
Did they, well, as my lady was saying a moment ago, I mean, if there's an allegation of current sexual abuse going on against a child, one would normally expect that the police would take that very seriously and conduct an ABE interview. But that didn't happen, did it?
It didn't happen. In fact, matters progress from this moment of record keeping to the point where CL speaks with both A and her peer. A denies having said anything to her peer and denies that there is any ongoing or any behaviour to report.
Right.
So all of that material is conveyed to the police by way of there was an updating referral. The police reopen and then we follow from there.
I don't want to take you out of order, but just if we stick for a moment, please, to page 608. What I currently find very curious about this document is that sentence in the final box was said by CL in her evidence not to be what she had written. So
Yes.
I'm just left wondering what on earth is going on with this document.
I agree, and it features in the judgment, as my lord has pointed out, that these were not her words.
But does the judge make anything of that?
No,
I'm looking at her judgment, paragraph 57. She records that evidence was heard by her. But what I don't know, and it's a very long judgment, I don't criticise it for that, I may have missed it, but does the judge address what may or may not be the significance of the fact that somebody else seems to have written in this?
No, and we don't know its origin. No, there is no significance attached to it.
Well, it may not have any significance, but anyway, I just find it very
No,
curious.
it is very difficult to follow. I mean, it's the occurrence occurred on the 10th, including the occurrence being the report to CL. But the report is written up the report is written up on the 11th, the next day at 10, just before 4 o'clock, 15:58, and that is the action taken in the action taken box. But some more stuff seems to have been added an hour later. Looks like it may have gone to someone else who added the box at the bottom. We just need to continue to monitor the report. we're not going to get to the bottom of this, but it's not entirely clear to me the whole form was filled in by CL.
No, it's part of a running record, my lord, and other members of staff were obviously responsible for some.
And nobody signs or puts initials on their bits. It's all very sloppy, isn't it? Anyway, there we are.
So, as I've already alluded to, this standout, as it were, piece of information is delivered to CL. There is an immediate denial by A of what the peer has reported.
Can you just? I find it very difficult to work out the sequence of events that happened on that.
Yes.
In November, and because of the technique the judge follows, going witness by witness,
yes, exactly.
there is. But none of the parties have either provided us with a clear chronology. I was hoping it would be clear from the chronology at page 50. Maybe it is. Yeah.
My lord, I hope the sequence is reasonably apparent in our skeleton, which...
Will you just show me the right passage? Perhaps it was.
Paragraph 20 is where we begin to see how it then unfolded. So,
but this isn't a chronological account.
It isn't, but I think I can help to piece together the parts that...
My lord, forgive me. There is, in the core bundle at page 648 and onwards, there is a chronology in a table.
Well, that was, if I may say, a very helpful table, which I did, was the one I used most, but I'm not sure it's helpful on this particular point. This is the one headed, allegations
Yes.
and retractions. Yes, no, perhaps you're right.
Thank you, Mr. Lamb.
But annoyingly, all the page references are not page references to any bundle we've got.
My lord, regrettably.
Could someone over the Court of German just mark up this with our current page references?
Yes, of course.
That would be a very helpful exercise. Might take longer than the Court of German, so one of the many juniors behind could perhaps start now. Or we could divide it up between them. Anyway, I see, yes. So in fact, you tell me, and you're probably right, I'm not going to waste time now, that if I go through this, I will find it carefully set out, as it were, minute by minute, insofar as the documents enable that. I mean, there's several entries for some days. Thank you.
So, my lord...
I don't know who did this document, but it was by far the most helpful, but somebody can take credit for it.
It's for discount, my lord.
Right, on we go.
My lord, I'm looking now at core bundle supplemental bundle 178, which is the statement of CL. She made 3 statements, but this is the one that I think is pertinent to the point.
So, sorry, I lost myself. Where are we?
Supplemental bundle 178.
Yes.
Here is CL making it clear that A did not make any allegations to her and denied all allegations, saying that her stepfather does nothing to her and she feels safe at home.
Sorry, can I just read this through? A's friend had reported the abuse to me. On this same day, a mass referral was done, so that's reference to the 10th, and both girls were spoken to. A did not directly make any allegation to me, the punctuation's all over but at this point, disclosures were made by A to her friend only. Is that consistent with 608?
608 does not, if I'm right, give detail of the fact that A denied.
Hang on 1 second, sorry, I just want to see.
Well, 608 quite clearly is consistent with that because
Yes, it is. Yes.
details of concern recorded. Blank approached me to discuss that
Yeah.
A had been confiding in her. A has told, not didn't tell me, has told blank that her stepdad touches her in inappropriate places at night. He checks on A at night, and this is when incidents will take place. A stated police and mum are aware, but as it stands, nothing will be going forward. So MASH referral made, both students have been spoken to, mediation.
Yes. And I'm afraid we asked.
Do we have the MASH referral?
No, we're just checking. I don't think we have it, but I'll be corrected if I'm wrong.
So we've got to be very clear then that in November of 2022, while some people may think that another allegation was made by A, that if it was made by A, it was made to a friend, and when the friend reported it to CL, A refuted it immediately.
Yes.
So it's always been, so far as A is concerned, nothing to refute, no retraction. It's not a retraction as such, it's a denial.
Yes, it's a denial. We have to move forward in the chronology from that because we get to another allegation. But at this
We get
point,
to what, sorry?
we get to another series of allegations in short order. But at this point, it's an allegation made to appear of ongoing abuse that is immediately and directly refuted by A.
Denied.
That does, yeah, denied.
Yeah.
So if I look at paragraph 20 of your skeleton argument, when spoken to by DL and the witness CL together, A immediately denied any sexual abuse had or was taking place. But then you say retraction 3 in brackets. It's not a retraction, it's...
No, it's an out denial.
She's just saying blank is not correct.
Yes.
I never told my friend that. That's effectively what she's saying. Yep, or my peer that.
There's another issue that is recorded which was reference to A reporting that her siblings were abused. And as part of the Section 47 inquiry outcome, of course there was a Section 47 that followed, A denied telling her friends that her siblings were abused. And later on in the chronology, on the 30th of November, when spoken to by a social worker, A is recorded as saying what she had said about her siblings being abused was not true. So we move from an allegation made to appear that her siblings were being abused to a denial that she had ever said that, to A saying that what she had said about it, accepting she'd said it, was not true. And this does not feature in the judgment. There is no indication that the judge gave any consideration to that evidence. So that's how matters stood as at the 11th of November.
Yeah.
On the 16th of November, a social worker came to visit at school. This was social worker TC. And she captured, she attended on the 17th of November, material that we have set out in our skeleton argument on page 6. It comes from her statement in the core bundle at page 406.
Yes.
Here, A accepts that she has told a friend that there is ongoing abuse. There is additional detail as to what she says she alleged was happening to her, which wasn't captured in the previous record. And A then says, well, this is, I was speaking about events that were historic, effectively. And so there's nowhere in the judgment where the judge gets to grips with that moving picture. And the clear evidence that A was, on her own version, saying something fundamentally untrue to her friend.
And what was that?
That the abuse was ongoing. On A's subsequent account, that was untrue. There has never subsequently been any allegation of ongoing abuse. What A then goes on to say is, these things happened in the past. I told my friend it was happening currently. This happened in the past until I was about 10.
So where do we see that A told her friend that it was still happening?
If we look at the top of the reference, A said that she initially told a friend at school via telephone conversation the previous week that her stepfather comes into her bedroom at night.
Yes,
And
but if you look at the second sentence, that doesn't necessarily mean that A is saying it is happening now.
No.
It's
Sorry.
no.
But can I? This is how I've understood it. Looking not only at this, but at the language of 608. What the friend says A has told her is that it is current. A tells TC that there was indeed past abuse, but it was only historic. I don't think A is saying that she told the friend that it was historic and the friend has misunderstood and thought it was current. I think the evidence is that A accepts that she led the friend to believe it was current, but it wasn't really current, it was always in the past.
yes,
In the distant past.
yes, that's
Sorry,
I don't know where that comes from.
rather
That is
stumblingly.
how we
Well, I think that's my reading of what the social worker TC is saying, read with CL's note of what the friend told her she'd been told.
I think that's the problem, because the friend is saying that she understood that the phone call drops off because the stepfather was outside the room then and there. This is, so A says no. When she's asked by CL, she says no. She
Yeah.
denies that. And then this is the piece of evidence you've taken us to, which you say is an inconsistency of A's, because A is certainly being inconsistent in the perception that her friend has, but that doesn't necessarily mean that A has led her friend to have that understanding. It could have been the friend misunderstood. So when you take us to this, I'm saying, where in this do you get the evidence from that you say indicates that A is being inconsistent, rather than there being an inconsistency between A and her friend? Do you understand this?
I hope I do. The only way I can tackle it is to say, to try and take it in sequence. The peer comes to school, reports that she's been told there is ongoing abuse, that he is touching her in inappropriate places at night. A immediately denies that anything has happened, ever. A then...
So who are they, what you say A immediately? Where? When? What do you mean by
to
that?
CL and DL. To CL and DL, when first spoken to, A says nothing ever happened.
Yeah, okay.
Nothing has happened. No, there is nothing to this. TC visits, and A says, as I read the record, as the evidence records, A says, I did tell my friend. I initially told my friend on the phone the previous week that my stepfather comes into my bedroom at night and...
Yeah, I think again that it may be an unfairness that you're perpetrating on the basis that if you read the paragraph as a whole, A is saying she did initially tell a friend at school via a telephone conversation the previous week that her stepfather comes into her bedroom at night and fingers her. She explained that this had happened in the past.
Absolutely. No, there is an allegation made, but the difference is it's not one of contemporaneous ongoing abuse.
I do understand that, Miss Howe. What I'm taking exception at is that you're drawing to our attention the inconsistency between the understanding of the friend and what A says.
I'm drawing...
And I'm just wondering if there's something that I haven't seen that draws them both together.
Nothing that we have access to draws these accounts together. There is no record of what the friend, beyond CL's note, there's no record of what the friend said, or any greater detail of what she says A told her.
Right, yes.
All we have is CL's record of current ongoing something happening, A's immediate denial, and then A saying, well, I did say something was happening, but something isn't happening now, it was happening in the past.
Yes, I was referring to the past.
Yeah.
Yes.
It's not clear whether A has ever admitted misleading her friend.
It looks on the face of it as though she does admit that,
Yeah.
because of how the note is recorded.
Either she misled her friend or her friend misunderstood the position.
That is a
Those are the two
potential,
possibilities.
but that is why we attach some significance to the phone.
But we have to remember that what we're ultimately doing is not trying to work this out for ourselves, but seeing whether the judge dealt with it adequately. So where does the judge fail in her dealing with this slightly complicated sequence of events?
It doesn't feature.
What doesn't feature?
The complicated sequence and the fact of what we say is an inconsistency. I mean, working on the basis that the account recorded by
So what we
CL
say is the fact
was
that-
right. Well, if one works on the basis that CL correctly recorded what the student said Z had said to her, and so long as the friend was not misunderstanding, there is a evidential difficulty in a child making ongoing
So is this your point? The judge never focuses on the point that lied about there being current abuse. That, you say, is clear, and that then is a highly important point in deciding whether she was lying also about past abuse.
Yes.
Now, I see this is speaking for myself being helpful to. It's just a kind of granular approach I think we need to take, though focusing not on what happened but how the judge analysed it. But time is beginning to run out. You're doing. It's understandable you will have to do most of the work. I'm sure that counsel for local authority will be. You need to do it in the same degree of detail. But how are you doing for time?
I am close to the end of submissions relating to the allegations, because we have one more.
Where are you going to go then? Then to the retraction?
Then to retraction.
And then that's it, effectively.
That is it, unless there are other matters that crop up.
Well, let's keep going then.
Thank you. So we had got to the statement made by TC at page core bundle 406. And the points that we made and continue to make about the way in which this set of allegations were captured or elicited were akin to those that we made in relation to DCL. In fact, the judge recorded in her judgment, paragraph 89 on page core bundle 77, that there were issues, that TC had shredded her notes, so there was no means to compare with her contemporaneous record. There were no case notes on the system reflecting her discussion with A. She had very little actual recollection of her discussion with A because of the passage of time. She was wrong when she told the court, as she did in oral evidence, that she had written the child's words down verbatim, because there were words used such as rekindle, intermittent, and penetrate that a child of this age was highly unlikely to have used. And she found that TC neither appreciated or adhered to the ABE guidelines, which she described as concerning. And yet she relied on this evidence without, we say, proper consideration of all of those evidential deficits that had a really material impact on the weight that was capable of being attributed.
It's difficult for you to say. The judge has been so explicit about all the difficulties with TC's evidence, and yet in the end relies on it. How can you say she didn't take account of those difficulties? Or are you saying that the deficiencies were such that it was perverse? Is this really a perversity point rather than a failure to take account of point?
The point I'm making relies on the case law about the need to appropriately analyse the robustness of allegations that are made of this kind of abuse, but with reference to the way in which the allegations are elicited, with reference to the guidance which is, as we've already said, there for a reason, so that there is a forensic basis to be able to be satisfied that the account is reliable. And we say the judge does not grapple with that. She alludes to difficulties, but there's no indication that she thinks about the weight that can and should attach to allegations that are obtained in a way which has so many deficiencies. And just to say, there is another, perhaps more granular point, which is that the allegations that were captured by TC did contain a fundamental inconsistency with those that had been made in January. Because in January, as you may remember, the central, probably the height of the allegation was of exposure of the penis and
Well,
licking.
you're taking a long time to make the point. She doesn't mention anything about licking his dick, and the earlier allegations do. Is that what you're saying?
I am saying that. In fact, it goes beyond that. It's not just that she didn't say anything about it. She actually is asked, it seems, and explained that her stepfather would not make her do anything to him. She said that he never took his penis out and he never tried to penetrate her. So we actually have evidence that she is made to think about. Has he exposed himself? Is there anything else? Has he made you do anything to him? And the answer was no. So it's not just that she didn't mention it, it's actually beyond that.
You're saying the judge doesn't deal with this either?
No, she notes it, and we're looking on core bundle 78, paragraph 91, where she says, I have taken this inconsistency into account, but with no other indication as to how. No analysis of the fact that this does go to undermine or potentially undermine the veracity of each of the accounts.
Do you also have a point if you look at paragraph 97 of the judgment, that the judge may have confused honesty with accuracy?
Yes, absolutely. That is a point that we, I think, have tried to make. The fact that a witness is honest doesn't help if the fundamental building blocks of their evidence are inaccurate or can't be remembered. And that was a feature in this case for a considerable number of witnesses. So CL was one, TC was another, DL another. The judge finds them to be witnesses of truth, but that doesn't get you over the other difficulties inherent in the case, which are, as I've alluded to, the capturing of the evidence being so weak. That, my lords and my lady, is the final iteration of allegations of abuse, because subsequent to that, and indeed in between, we have evidence of retraction. And I know I'm short on time, but the fundamental point I'd like to make about the retraction evidence is that there are a number. One, the ABE interview was conducted very robustly. In fact, that's where the breaches of ABE guidelines come in by DCL, because he pressed and pressed to understand, in fact, he accepted in evidence he did this, to try to understand whether this was a retraction under pressure or whether it was a true retraction or denial, however we want to phrase it. And that's why he asked leading questions. That's why he put to each of the things she had said previously had happened to her and questioned whether somebody had put pressure on her. And the answer that he got was no. And his overall evidence in front of Her Honour Judge McKinell was that he found the retraction to be cogent, to be reasoned, and he had no reason to think, in his experience, that this child there was no evidence of pressure to retract. There was nothing that she said that meant he felt this was not a true retraction. And the same can be said for when TC revisited Zara A on the 30th of November, where one of the retractions that we rely upon was offered. And we make this point at paragraph 61 of our skeleton. At CB 79, paragraph 95, the judge records that TC agreed in evidence that she had been tasked to go to find out if A had been pressurised, to say that the allegations were untrue. TC said in her own evidence that she found no such evidence, that as far as she was concerned, the retraction was coherent, was rational, was reasoned, and it was, and there was no evidence of pressure in the way in which A presented at all. Yet the judge just doesn't focus in the judgment on the material about retraction or denial or refutation. She analyses that she doesn't accept retraction on the basis, she says, of pressure that's been brought to bear on the child. But nowhere in our submission does she tackle the fact that these retractions have been received by trained professionals tasked to try to find out if this child has been pressured, and none of the witnesses who had received retraction either obtained any such evidence or reflected their view that there was something in this child's demeanour, something in what she said that gave rise to concern that she had been unduly influenced or pressured. And we say that's a real deficit. And here we've got a child who is now 14, competent child, saying again and again.
You said you've got several points on retraction. That's your first, is it? Or are you running lots of them together? The first was that these were ABE interviews done robustly, and the professionals conducting them saw no reason to doubt the retractions.
So that's point one about DCL. TC did not do an ABE.
Yes, sorry. Okay.
Her account, it matches in terms of the.
Now, I just want to be clear what your points are, and if your time is short, I think you can make them succinctly. But I wasn't sure whether you're still on the first one or whether you've moved on.
That will do for my first one.
Okay, right. What was your next?
My second is that these are retractions by a now competent child, a child who was 12 at the time she first made a retraction, and who is now 14, competent to instruct, and continues to tell this court that her allegations were not true. A third point, if I may, the way in which the retractions were tested is outstanding in our submission. If we go, please, to page 16 of our skeleton, subparagraph 11. This is about a visit on the 9th of May. I'm sorry, I've taken you to that wasn't the reference that I meant. I do apologise. I think we need to go back to page 14, please. And in this episode on the 15th of April, in our submission, A was put through the ringer by the IRO and with the social worker including the part in bold that we've highlighted, the IRO saying in terms to A that she doesn't believe she made the allegations up because she had given specific details about the incident and how it had occurred. And then, as we can see from the extract, being challenged time and time again about, we don't believe your retraction, we think something happened. You need to tell the truth. There are consequences for not being truthful.
What is your point?
The point is that the retraction stands up despite enormous pressure being brought to bear on this.
So your point is that stands her ground despite the enormous pressure on her. Yep.
And shortness of time means I won't go through each and every one of the episodes where this child has...
Well, not so short of time that if there are points you feel you ought to make, you should make them. But I'm just anxious you make them succinctly. Up to you. I mean, you're the best judge.
Thank you. Let me just then think. So, again, time and again, the judge, time and again, A says to the professionals the rationale she has for having made these allegations. She talks about home life and about feeling left out and about wanting...
Sorry, you're competing with something outside.
She talks about home life, feeling left out, wanting more attention. And that is a consistent theme. The judge just, in our submission, doesn't tackle that appropriately. She focuses purely on what she surmises or suggests is pressure on this child to retract. Nowhere does she give weight to or analyse the rationale for these allegations having been made. And the fact that there is a consistent theme. Every time A is asked, she tries to tell the professionals, was trying to tell the judge why she had made these allegations in the first place. And yet, there are 2 points that emanate. One is, you would not know from reading the judgment how many times this child has attempted to retract, because many of those instances are not reflected in the judgment. You would not understand the consistencies that lie there in the evidence of retraction. Consistencies which far outweigh the consistency of the allegations which we've looked at. You would not understand how these retractions have stood up evidentially to being tested by professionals. And so in the judge offering a rationale for retraction, that's one thing. She, of course, can form a view about that. But what the judgment lacks is balance. It lacks the judge giving weight to each side of the picture to form her ultimate view that these allegations were true, whereas the retractions and denials were not. The judge forms the view that A is a truthful child. That is ultimately one of her key findings. And yet, in the judgment, she does not grapple with the fact that in saying that, she must accept that A has lied consistently to professionals again and again and again. She does not grapple, as we've already alluded to the fact that A, on the evidence as it stands, appears to have made allegations of contemporaneous abuse, which she then denied. So that's a smaller point in the bigger picture, which is that in our submission, that finding that she is ultimately a truthful child is very difficult to square with the evidence of retraction,
Well,
the
you've just made
coherence
that
of it,
point.
and the judge doesn't grapple with it. And as I've said, in the skeleton, we make the point that a number of these opportunities, issues of retraction, are just not mentioned. So the retraction to Dr. Powis in the course of the assessment, Core Bundle 451, paragraph 5.89, where to this professional, A explains her reasons for lying. No one was listening to her. She thought her mum was ignoring her, not worrying about her. She was annoyed that T was calling KK dad, who thought that KK was trying to steal him. These were the child-appropriate rationalizations for why she had made things up about KK. And yet this evidence doesn't even feature in the judgment. You wouldn't know it had happened. And whilst I know, of course...
So this is specifically the retraction to Dr. Powis and the rationale given to Dr. Powis for the lies are not mentioned by the judge. Is that it?
The retraction is not mentioned. The rationale, I hesitate to say that the rationale isn't mentioned. The specific conversation with Dr. Powis isn't mentioned. There is, I think, in the judgment a part of where the judge analyses life at home and determines that she doesn't accept that the retractions are born of the truth. But the weight, this point is really about the weight of the evidence and the fact that the judgment just does not give you an adequately clear picture of the weight of the evidence of retraction and how the judge has managed it. She forms a rationale for the retraction and sticks with it. But that, in our submission, is not enough in the context of this case, where she has to weigh a set of allegations of serious abuse against the other evidence that from the child that refutes it. And we say the judgment just doesn't adequately manage that process. It fails to mention key evidence and it just doesn't deal with it. So that, I'm conscious of the time, are the points that we make about retraction.
Yes. Okay, well, that's helpful. Now, does that mean that is substantially, of course, we've got all your skeletons, but in terms of oral submissions, is that all you wish to say?
I will, of course, trust that you're...
Well, I wonder whether this isn't the sensible course. Everyone accepted you have to take the burden of this, and you have. Why don't you, over the short adjournment, speak to Mr. Forgive me if I mispronounce him, Tuan. I haven't mispronounced him. And Macur, see whether there are points that they want to make. If so, whether they are, and whether in the light of the points you know they're going to make, there's anything more you need to say, or vice versa. They may say, you've said everything. And but I don't think that, as it were, the appellant's team can go much into the afternoon.
I understand, and of course
So I'm very willing to leave it to the wisdom of counsel to decide what the best way is of presenting any remaining points. But there certainly are one or two points specific to the mother.
Yes, indeed.
Which will need to be made. And
I'm confident I can make them shortly.
Good. Well, that is helpful. Well, I'm not going to put an exact time limit on it, but the appellant's team will have to finish pretty early in the afternoon. That's not going to create any difficulty effectively. There's only, well, Well, I'm not sure who I'm supposed to be looking at, sorry. Mr. Lamb, how are you going to be on this?
My lord, I suspect a little shorter than the appellants.
Yes, well, that's to be expected, but you will need some time.
Yes.
And then there's a question whether we'll need to hear on what aspects of Mr. Toby. Do you have a feel about it at this stage, or to wait and see how Mr. Lamb goes?
I have a feel it would just be a matter of adding a few submissions.
Yes. Well, I think we're on time, but I think we're only on time if people are going to be succinct. Good? 2 o'clock.
All rise, if able.